Hi everyone, my name is Dan Shaw. I'm managing editor of both the Daily Reporter and the Wisconsin Law Journal. And thank you all for being here today, and thank you to our panelists. Hope we have some matters concerning both the law and construction that will be of interest to you to discuss. And anyway, I guess I should do a quick introduction, or perhaps you all can introduce yourselves really quickly. Okay.
Excuse me, I'm Don Gallo. I'm an attorney with Husch Blackwell that is located in St. Louis, and White and Hirschbeck merged into Husch Blackwell. So you may know the White and Hirschbeck name. I practice environmental law and construction law.
I'm Matt Fleming from the law firm of Burke Desmond, primarily in Madison. We also have an office in Janesville and another office in Appleton. I practice land use, zoning, do eminent domain litigation, some property tax assessment, and also represent some municipalities in the Madison area, including the city of Milton.
Good morning, my name is David Henry. I'm an attorney with Kohner, Mann, and Kailas here in Milwaukee. And I practice construction, lien, and bond law in all 50 states. I focus on recovering construction receivables for subcontractors and suppliers. I have a network of attorneys I use in each state if necessary to assist me. So I'm kind of a one-stop shop for those kind of claims.
All right. Well, I guess we'll have a few questions planned for everyone of our panelists. So I think start with one and ask one question, move to the next one, ask another. So I guess I'll start with Mr. Fleming, since I have you first on my list. We were just talking up here about a very large bill, omnibus bill, you could perhaps call it, Assembly Bill 770, and it's going to make a large, wide-ranging number of changes to various parts of the law concerning, it seems like mostly residential development, I guess is a good way to summarize it. But anyway, one thing I wanted Matt Fleming to do is summarize this bill for us and tell us a little bit about what he thinks is good about it and what he thinks is bad about it.
Sure. Well, I'll just say it is a very large bill, and sometimes I think maybe a little larger than the initial drafters maybe realized when they got into it. The three things that really stick out to me that I think may be most impactful here is first, and the one thing that really has very little to do with residential development, and that is the really redefinition of relocation payments in eminent domain cases. Relocation payments, if you don't know, typically in eminent domain you get paid just compensation for the value of your property taken, and that's constitutionally required, but then Wisconsin has another set of payments called relocation payments that are essentially assisting with moving expenses and to try to, get you set up again at a new location. And for years, these payments were limited to, I think if you're a tenant operator of a business, to about $30,000, if I recall. And if you're an owner occupant, $50,000. Those limits are now getting increased, which I think is a good thing. Not necessarily expressing an opinion on the amounts they have chosen, but I think they're going up to $150,000 respectively. But those, am I getting some feedback here?
Yeah, you are. Speaker's right behind you. Yeah.
Maybe, is that a little bit better? And so those flat, like any flat amounts that are put in statutes, I think those need to be altered now and again. But I think the two biggest changes that are coming along with this that could have serious ramifications is they've reworded the statute in the latest substitute amendment such that these upper limits on relocation payments now only apply to cities, villages, and towns. And one of the biggest users of the power of eminent domain in the state is the Department of Transportation. And so to the extent we've got DOT projects now that are going to require relocation of businesses and farm operations, the DOT is no longer protected by any upper limitations on relocation payments if the bill as currently drafted goes through. The other major change in this regard is adding a new element to what is compensable in a relocation payment, and it's what they're defining as reasonable project costs. And there's several sub-definitions of what is a reasonable project cost, but essentially as I read it, it sounds like just about anything that you have to pay for up to reconstruction of an entirely new improvement. And in my view, that could really dramatically increase the costs of road projects or anything where you need to exercise the power of eminent domain, because what I think can end up happening is oftentimes you're going to end up paying the value, compensating the property owner for the value of the property taken, but also a lot of the new cost of the new property. And it seems like there is some serious potential for overlap and double payment for the property taken, which is naturally going to increase costs significantly. As far as park fees, the major change that seems to be going on there is folding in park fees into the impact fee statute. And for years, park fees have been paid either park fees in lieu of land dedication for park, but also fees to help improve parks for new developments. Typically, those have been required to be put up by the developer up front with the idea that so they can get the parks built, so the first few residents in the development don't have to wait for the parks to be improved. And part of what's gone on, I think, is a lot of communities have not kept up on the required park fees, and the parks are not being improved very quickly. And this seems to be a response to that, although I'm not sure if it's the best response to that. But by putting park fees into the impact fee statute, what that means is that you're no longer going to collect the fees up front. They're typically going to be collected at the time a building permit is issued, or under the new bill, 6 months before the fees are planned to be expended. And that could create some potential collection problems and so forth. But I certainly think in that regard, there do seem to be some issues. I was speaking with one developer who was a major backer of this bill and explained to me that in the city of Madison, he has a development where the neighborhood area park there, it's going on 10, 15 years since the first houses have been occupied, and the park has not still been fully improved. Now, my real question to that is, well, why is that happening? I don't necessarily think it's because the city of Madison just doesn't believe in improving the parks. And that's another problem I fear with some of these changes. It's not as much an issue of, are these problems that need to be fixed, as much as, are we really asking the right questions? Are we solving the problem or just attacking a symptom? But then finally, one thing that I think does hold a lot of promise is changes to the TIF law for creating workforce housing TIF. Right now, tax incremental financing, the ability to use that to create affordable housing for single-family homes is extremely limited, and this would expand it significantly. It basically allows some TIF districts to be created as long as they're quarter-acre lots and a few other restrictions that are designed to be able to create affordable housing for working families and creating housing for employment, people that need to have jobs and so they can live in close to the places where hopefully we're creating the jobs. And I think that holds quite a bit of promise, both for localities as well as the construction business. I know I've seen a lot of areas where people have tried to come in and do affordable housing, and there have been some hurdles there, both imposed by some local governments and as well as just the financing of it. So that I think could be very helpful. I think the one concern I see there is I know they've wisely put in some changes to the levy limit law so that municipalities can raise their levy limits by, I think it's $1,000 per new housing unit. And that's necessary because with TIF districts, all new tax increment created has to go be held in the TIF district and can't be spent. And housing, residential development typically creates the biggest new impact on municipal services. So there is that need to have that additional tax revenue to be able to serve the new development. What I'm not so sure about is whether the school districts have been adequately considered in that, because if you have a lot of new residential development, there's also going to be a lot of new students. And does the state's funding and adjustments for students and pupils, does that adequately compensate school districts to be able to handle that new influx? So that's one little twist, but other than that, I think that could be a very positive development.
Yeah, I was going to follow up with a question. You were talking about the eminent domain part of the bill. Now, when you said that there's no limit, you're using an example of a DOT project. You know, that there would be no limit on the type of compensation that the DOT would have to offer. Is that exclusive to the DOT, or would that be any sort of government that takes property using eminent domain?
Well, it would be anything but cities, towns, and villages. They've changed the language. They've eliminated one section, and then they've said, basically, if the condemner is a city, town, or village, the total relocation payments can't exceed either $100,000 in one case or $50,000 in the other case. So basically, any other entity that can use the power of eminent domain, and that not only includes governmental agencies like the DOT, but for instance, American Transmission Company, utilities, both public and private utilities, railroads, although I don't know how much condemnation has gone on in railroads lately, but who knows what the future may hold. So it really hits a broad scope of other entities that hold the power of eminent domain.
So in other words, if someone's going to use eminent domain to take your property, make sure it's not a city or a village, one of these others, you can soak them.
Well, and in many instances, you may not bump up against the limits, and certainly there is still some degree of limitation in the definitions, although I think we're really going to see this new definition of reasonable project cost. It's really hard to look at it and see where those limits exist, and certainly there are plenty of folks out there like myself and the gentleman sitting at this table that are going to test those limits. But it does seem very broad, and I just don't I don't know if the cost of that has been, because right now, for instance, I have not seen, there are fiscal estimates that have been filed from the DNR and from Department of Revenue, but as I said, the Department of Transportation is the biggest user of eminent domain there is, and so far I don't think a fiscal estimate has been received from DOT, so a big unknown.
And the other thing I was going to ask, and I think we talked a little bit about this in email, the part of the bill that you were talking about creating TIF districts for workforce housing. Have you seen any indication that this has to do with the Foxconn project? Because we've heard how many houses are going to have to be built for that.
I have not heard anybody directly connect Foxconn to this proposal, although I wouldn't be surprised if that was in mind. Certainly the expectation is that Foxconn is going to be creating many jobs, but maybe lower to mid-range sorts of levels of compensation, which may require some work in this type of bill to be able to construct affordable, at least single-family type housing. The other option is putting all those workers into multifamily housing, and is that something that we want? There's policy choices involved in there, but I don't think I don't think it was exclusively Foxconn that brought this about.
All right. Well, speaking about Foxconn, actually leads into some of the questions I had for Mr. Gallo, to to my left here, so I might circle back to Mr. Henry after this, but we were talking a little bit about the Foxconn project when we were talking about this event, and of course, one of the biggest things that's happened around this project, one of the things that stirred up the most controversy is the state legislature lowered the wetland requirements attached to this project, the standards that developers have to meet to proceed with this project. I didn't know if you could talk a little bit about that and then talk about and talk about the bill too that's come out since then.
Yeah, I'd be happy to do that. I think it's really, the bill is actually called Act 58, and it's really very creative. It depends upon your point of view, but I think the environmental concerns that people have are probably overstated. And let me explain how this works. What the legislature created was an electronics enterprise zone for electronics manufacturing. So within that zone, and this is not really unusual because the legislature has created agricultural zones as well within the state historically. So in this instance, they created an electronics manufacturing enterprise zone, and within that zone, the rules change a little bit, and I can see why. Let me explain. The wetland process is the first step. Is you have to do what's called a practical alternatives analysis, and you have to justify to the DNR why you need to fill wetlands, and you have to evaluate all your other alternatives to avoid filling or minimizing the fill of wetlands. That usually is the longest lead time in a wetland fill application, and it's also costly and complex because it's an iterative process. You submit this to the DNR and they review it and they have questions, and you revise it and resubmit. What the legislature did is they eliminated that step, and they said development within the enterprise zone does not require an alternatives analysis. It's just presumed that you can fill. In trade for that, they increased the mitigation requirements. So on the Foxconn projects, there are 42 isolated wetlands. And isolated is a key term, and I'll try to explain that. But there are 42 isolated wetlands that comprise of 26.5 acres, which is large. That's a large fill. The average fill is like a quarter of an acre, 10,000 square feet, that type of thing. That's what I'm more accustomed to in a normal development. But this is 26.5 acres. Normally, when you do that fill, and if you pass the practical alternatives test, and then you're allowed to fill, you have to mitigate. And the mitigation ratio is 1.2 to 1. So roughly you would have to mitigate about 31 acres to fill 26 under the old rules or the standard rules. In the Foxconn bill, it's a 2-for-1. So Foxconn has to mitigate 52 or 53 acres in trade for the filling permit. What's really interesting is they have 3 options on how to mitigate. One is you can buy credits in a wetland bank. 2 is you can do your own mitigation, and that's very costly and complex. And 3, you can just pay into the DNR. They have a program called the in lieu fee program. So you just pay so much an acre, and usually it's $35,000 to $40,000 an acre to be able to fill. And so Foxconn, the numbers are, Foxconn would pay 53 acres, somewhere around $40,000 an acre, so it's about $2 million. So basically just buy your way out of it. And that's only for isolated wetlands, because wetlands are regulated by the state and also by the federal government. But the reach of the federal government is only with regard to what's called waters of the United States. And waters of the United States have to be connected to a real stream or river, as opposed to an isolated wetland that is only regulated by the state. So just last week, the federal government, the U.S. Army Corps of Engineers, reviewed these 42 wetlands and determined that all 42 are isolated wetlands and they have no jurisdiction. So that was at risk. If they had determined that there were a couple wetlands that were under federal jurisdiction, then they would have to go through, Foxconn would have to go through the practical alternatives analysis. The advantage of what the legislature did is save Foxconn probably 3 to 6 months at a minimum in time for construction. So not having to do the practical alternatives analysis saved Foxconn 4 to 6 months in time before they could actually start construction. So you can see the reasoning. What they're paying for is a 2-to-1 ratio instead of 1.2-to-1. And so this all ties in very nicely with what Trump is trying to do on the federal level, and also what there are 2 other bills in the state legislature that are pending right now on wetlands. And should I explain those?
Yeah, sure. Yeah.
Okay. What's really interesting is this is really to somebody like myself is really interesting because it's a moving target. So what Trump is trying to do is he's trying to pull back a 2015 regulation that was being implemented by EPA that determines what is a federally regulated wetland. And so the determination was by the Supreme Court, and it has to be hydraulically connected to a water of the United States. So you have to have a stream that's adjacent to or somehow connected to the wetlands. If you don't, then that wetlands is isolated, and the federal government doesn't have jurisdiction. And so the farmers are all upset with this because they have farm ditches, drainage ditches, that then connect up wetlands, and so that brings the federal government in on farmland. So what Trump is trying to do is say this connection is extreme and it should be cut back. So they're trying to cut back the extent of federal regulation of wetlands. Now there's 2 bills in the state legislature that have incredible effect if they get passed, and there's precious little time left, but these bills are really poised for approval, so I think they may get passed. One is the state legislature is going to exclude artificial wetlands, which makes infinite sense. These are artificial wetlands, or wetlands that were created essentially man-made. They're roadside ditches. It's incredibly expensive to get rid of an artificial wetland. They're generally very small, and I think it makes sense. And the DNR is already starting to approve permits on artificial wetlands and kind of streamline that. So that's a give me, I think. What's a real big issue is that there's a bill, and it's already been approved by the Senate Committee on Natural Resources, 5-0. And this bill would eliminate DNR's jurisdiction over isolated wetlands. So you already don't have jurisdiction over federal wetlands, or federal jurisdiction over isolated wetlands. The bill now will take away jurisdiction over DNR's jurisdiction over these isolated wetlands. And the bill says that only 20% of wetlands are isolated, and I don't really believe that. I think it's more like 30 or 40%. But if that passes, then there's going to be a rush to fill wetlands that are isolated, and it's real streamlined. You have a requirement to give DNR notice 15 days notice before you fill. DNR has to review and object to that filling, and if they don't within the 15 days, then you're automatically granted the right to fill. What I'm not sure of is whether you have to mitigate, but mitigation is kind of frosting on the cake if that's required. But the big deal is that you could fill isolated wetlands. And I'm going to recommend to a number of clients that they move quickly on this, because that can quickly be reverted if there's a change in administration. So that's the wetland scene.
Wow. Yeah, that sounds like pretty sweeping changes there. Do any of other panelists have a question for him? Or yeah, that's pretty remarkable. Was that more or less what they did with the Foxconn project, or maybe I should put it this way, after other developers saw what was happening with the Foxconn project, and they started clamoring and say, well, wait a minute, why are these guys getting this break? Why can't we get the same thing? Is this a result of that type of...
It probably is. It probably is. What I found really amazing is that, I understand the state legislature wanting the Foxconn project to be streamlined and granting the wetland issue. What I found to be amazing is that Federal Army Corps of Engineers concurred with that. So, they could easily have said, well, 5 of these 42 are connected in some manner, and it could be a groundwater connection. Therefore, you'll have to, on these 5, you'll have to go through our jurisdiction. But they agreed that all 42 were isolated, and the project's on a fast track.
All right, well, speaking of the federal government, and perhaps not on a fast track though, the next question I had was for Mr. Henry at the end of the table, and has to do with the federal infrastructure plans. Of course, Donald Trump, one of his central campaign pledges was spending $1 trillion on infrastructure. And who knows when that's going to happen. We can hear rumblings that there's going to be a plan announced very soon. But in the meantime, the economy has been strengthening, the stock market's been booming. There's lots of optimism about the public sector construction. It's going to provide a lot of opportunities for contractors and material suppliers who help to build public projects. And obviously there's going to be an increased need for labor and materials. I was just wondering, as subcontractors start to get involved on these projects, and I understand that's your area of expertise, Mr. Henry, as they start to get involved, what steps should they be taking or thinking about taking to ensure that they will receive payments, the payments that they're owed, and otherwise protect themselves?
Yeah, thanks, Dan. Presumably, most of the new infrastructure projects are going to be federally owned. So the remedies available to unpaid subcontractors and suppliers will be those that are available under federal law rather than state and local law. And there's a statute called the Federal Miller Act that comes into play. Subcontractors and suppliers do not have mechanics lien rights on federally owned projects. So in lieu of lien rights, Congress passed the Federal Miller Act, which gives certain subcontractors and suppliers a right to assert a claim against a payment bond furnished by the general contractor on the project. A payment bond is somewhat like a guarantee or an insurance policy issued by a surety, which is usually an insurance company, that in essence guarantees payments in accordance with the terms of the Miller Act, which has a number of hoops and deadlines you have to jump through. The court cases under the Miller Act regularly hold that a subcontractor or supplier has a bond claim right only if its contract is with either the general contractor or a first-tier subcontractor. So if your contract is with a second-tier sub, which is a sub to a sub, you will not be eligible for a bond claim to be confined to a claim against your customer. So that's important to keep in mind. There's only 2 tiers below the general contractor eligible to assert a bond claim under the Miller Act. Generally, the amount of the payment bond is equal to the amount of the general contractor's contract with the federal government. So, okay, sorry about that. So there should be enough funds there to pay all the subs and suppliers should the general contractor run into financial problems. There are very important, as I mentioned, notice requirements under the Miller Act. If your contract is with a subcontractor rather than the general contractor, this is probably the most important thing to remember. You must give notice of your bond claim to the general contractor within 90 days of the last date that you furnish labor or materials for the job. If you miss that deadline, you will lose your bond claim. It's a hard and fast rule, and it's essential to meet that deadline. This notice must be in writing, and it must specify the amount claimed and the name of the party supplied, and should also make a demand for payment and state flat out, I'm making a claim against the payment bond. The notice must be given to the general contractor by the Miller Act, but it's good practice to send it to your customer, to the job owner, and to the bond company as well, because that's very likely to help facilitate getting the process started that may lead to payment. The best method there are a variety of methods available to give this notice, personal, FedEx, but I find the best method is by certified mail return receipt requested. And make sure you keep all of your green card receipts, because that could be valuable evidence if you end up going to trial. The notice needs to be actually delivered within 90 days of last furnishing, not just put in the mail. So you want to make sure that you send it out far enough ahead of the 90-day deadline that they get it on time. Because if you send it out on the 89th day and they get it on day 95, you've lost your bond claim. Another important deadline under the Miller Act is that a lawsuit to enforce your bond claim, if you're not paid voluntarily by the bond company, must be filed no earlier than 91 days from the last date that you furnished materials or labor for the job, but no later than 1 year from that last furnishing date. Again, if you miss that deadline, you will lose your bond claim. The suit needs to be filed in the federal district court where the job is located. So if it was a Milwaukee job, you'd file a suit in the federal district court for the Eastern District of Wisconsin. One of the things that I think is essential to do at the start of a federal job is confirm that the job is in fact bonded and obtain a copy of the bond. A lot of times you can get a copy of the bond fairly easily by just taking informal methods. Send an email to the general contractor's project manager, or make a phone call to the federal contracting agency's contracting officer and say, is the job bonded? If so, can I get a copy? I'd say about 75% of the time that works, but it doesn't always work. But there is a mechanism in the Miller Act that you can utilize to force them to give you a copy of the bond if they won't voluntarily do it. It does require an affidavit be submitted that basically states, I'm a sub or a supplier on the job, I'm owed money on the job, and I want a copy of the bond. Sometimes they'll try to say, no, you need to request it under the Federal Freedom of Information Act, but that's not correct. The Miller Act gives you a right to that bond as long as you submit that affidavit. Getting into pre-performance bond claim waivers, the Miller Act does not allow the general contractor to insert in its contract with a sub a clause that says, I hereby waive all my rights to a payment bond claim under the Miller Act. That is not enforceable. But they'll try to do it anyway, and it does happen, but it is not enforceable, and it's helpful to know that. If in the event you're not paid, you have to pursue a bond claim and you discover such a clause in your contract. However, written post-performance waivers are enforceable. So once you've started furnishing labor or materials and you sign a waiver, it's enforceable. And also, another thing to keep in mind with those waivers, which they ask for when they're going to make payment, be sure to give a conditional waiver in return for a promise of future payment, and hold off on giving the unconditional waiver until payment in good funds has been actually received. The difference between a conditional is, conditional means upon my actual receipt in good funds of the sum of X dollars, I shall be deemed hereby to have waived my bond claim to the extent of the payment. An unconditional says that you acknowledge receipt of the payment and waive your bond rights right away. A lot of times I want to get that from you saying that we're going to have a check in the mail pretty soon, just send it to us and we'll hold on to it. But you can find out that a surety, you may not get paid or there's a stop payment on that check, and the surety may be able to rely on that unconditional waiver and say you lost your bond claim. So that's a very important thing to keep in mind. Getting into material suppliers, they have bond claim rights only if they furnish materials to a first-tier sub or the general contractor. But one of the big things with material suppliers is if you're selling materials to another supplier, generally you will not have a Miller Act payment bond claim right. You will lose that right. Suppliers to suppliers do not have generally federal Miller Act payment bond claim rights. There's a few exceptions to that rule. In some cases, you might be able to show that the second supplier is customizing, say he's buying materials from you and he's customizing it for the job. You might be able to argue he's really a sub, he's not a supplier. Another situation where there may be an exception to the supplier rule is if the general contractor says, well, I want you to furnish these materials, but this guy in between, he's going to mark it up 10% and sell it to me, which is sort of a strong man kind of a situation. You may be able to argue that middle supplier should be ignored for purposes of determining your eligibility for a Miller Act claim. Another issue that can come up in federal Miller Act bond claim cases is you may find there's a pay when paid clause in your purchase order or your contract that says, I, subcontractor A, do not have to pay you until I'm paid by the general contractor, or I, general contractor A, do not have to pay you, Mr. Subcontractor, until I get paid by the owner. But generally, that will not prevent the enforcement of your payment bond claim, even if your customer hasn't been paid yet. And one of the reasons for that is there are very strict deadlines for filing suit to enforce a Miller Act bond claim 1 year from last furnishing. That statute of limitations could expire if you had to wait until your customer was paid to pursue your Miller Act bond claim. But they'll stick those clauses in there anyway, but it's important to know that they won't prevent you from pursuing a Miller Act bond claim. One important thing a lot of people probably are concerned about with Miller Act bond claims is, I've got to spend the money to file suit and enforce my bond claim. Do I get my attorney fees? Do I get my interest, prejudgment interest? The attorney fees are pretty tough to get in most cases. And there's sort of a split in the courts about whether you can get prejudgment interest against the bond company. But certainly attempt to get it if you have to file suit. Another thing to point out is that some of these infrastructure bills may end up being state jobs. They may not be federally administered. Like some highway jobs.
You want to try this mic? It might be,
Better? Okay. Some highway jobs, for example, there may be federal funds coming in, But the Wisconsin Department of Transportation, or whatever state is in, may be administering the contract, letting the contract, and funding the job using in part the federal funds they got. In those kind of situations, the Federal Miller Act would not apply. And then you need to look to the bond laws of the state where the job is located. In this case, if it was a Wisconsin job administered by Wisconsin DOT, the Wisconsin payment bond law would apply. How are we doing for time, Dan?
We're getting close to 11:45, but we can go a little bit over.
Okay.
Go for a little bit.
I'll touch a little bit on the Wisconsin public project remedies. Under Wisconsin law, there are two main remedies available for an unpaid sub or supplier on a public project: a payment bond claim and a lien on funds claim, which is a little different from the Federal Miller Act, which does not recognize a lien on funds claim. And a lien on funds claim just means a lien on the money owed by the government agency to the general contractor. It's not a lien on the real estate or the job site, but on the funds. Generally, under Wisconsin law, subs and suppliers are eligible to assert a claim against the prime contractor's bond, like the Miller Act, if they furnish labor or materials to the prime or a first-tier sub. But there's an exception to that rule for highway projects. On state highway jobs, only those furnishing labor or materials to the prime contractor are eligible bond claimants. It's a pretty narrow statute. Well, there are certain exceptions generally to preserve a claim against the bond under state law. Subs and suppliers who do not have a contract with the prime contractor must serve a written notice of furnishing on the prime contractor within 60 days of first furnishing labor materials for the job. First furnishing, not last furnishing. The exceptions, some smaller jobs or smaller claims under $5,000, certain employee claims, and there's an important exception where if you are listed in the statutorily required list of subcontractors to be maintained by the general contractor, he already knows about you, and you don't have to give that 60-day notice of furnishing. Interestingly, unlike the Miller Act, there's no requirement that a claimant serve a notice of non-payment and a notice of bond claim on the prime contractor. But there's a few cases out there that hold that if the bond itself says you need to give such a notice, you have to do so. And that's why it's important early on to get a copy of that bond and review it. And if it's got a notice requirement in it, even though the statute doesn't require it, it's prudent to send out the notice in accordance with the terms of the bond. And a lot of foreign bonds do have a 90-day notice requirement that runs from last furnishing. So get a copy of the bond, and if you're afraid that you may not get paid on the job, review it carefully and satisfy the notice requirements. Under Wisconsin law, there's a bit of an ambiguity in terms of when you must file suit to enforce your bond claim. It's 1 year from the completion of the job as a statutory language. But what does that mean? The completion of the entire job, the completion of your part of the job? It's a bit ambiguous, so the safe thing to do is err on the side of caution and sue within 1 year of the date you last furnished labor and materials for the job. That way, you know that you're safe, and that's kind of a conservative way to resolve that ambiguity. As I mentioned earlier, Wisconsin law also provides a lien on funds remedy to subs and suppliers, and that is available on public jobs, but it's available only to subs and suppliers that have a contract with the prime contractor. To preserve a lien on funds claim, the claimant must give written notice of its claim to the public government entity that led the contract and the prime contractor, And that notice must be delivered while funds are still owed to the prime contractor. So if they've already paid the prime in full, your lien on funds claim is going to have no value. But you still may have a bond claim, depending on whether you satisfy the requirements. If it's a state job, you would serve it on the State Department agency that is administering the contract. If it's local, you serve it on the municipal clerk or the municipal treasurer. Generally, if the lien on funds claim is not disputed within 30 days of the date you give notice, it is deemed to be a valid claim. But there's one other step you've got to take to get paid, and that is give written notice it wasn't disputed within the 30-day period and demand payment. But if the prime disputes it within the 30-day period, then you'll have to file a suit to enforce that lien claim. And the suit must be brought within 3 months of the date you give that notice. In Milwaukee, there's a city ordinance that's a little bit different that applies to the lien on funds claim. Basically requires that notice within 20 days of last furnishing. So it's a little different if it's a city of Milwaukee special ordinance that applies. And finally, there's one other remedy that I don't think it's very often used in Wisconsin, but it's called the theft by contractor or trust fund statute. And basically, what it does is that any funds paid to the prime contractor or one of its subs that are supposed to be paid to a lower tier party are to be held in trust by those parties for the benefit of the unpaid subs and suppliers. And a lot of times you may find out, gee, they got paid and they didn't pay me. And that may be a violation of the theft by contractor or trust fund statute. And there can be criminal penalties and civil remedies for that kind of a situation. There's no similar statute under federal law, so that's a state, Wisconsin state law based. And some other states have the trust fund statute as well.
Okay. Well, thank you. That was a very comprehensive look at lien law and public contracts. I think you only left out one thing. You're supposed to say that law is obviously very complicated, so make sure you have a good lawyer. But I don't know. Are you guys pressed for time? Did you want to try to do the summary before lunch, and that way you can leave whenever you want to? Is that better for you? You think? Or we were talking about having them do a summary after lunch, but maybe it would be best to do it now, and that way everybody can eat and leave at their own pace. So I'll just hand the mic to you, and if you wanted to just go over some of your main points really quickly.
Sure. I talked about the Foxconn project and the creation of electronics manufacturing enterprise zone. And we talked briefly about how the environmental laws were relaxed with regard to wetlands. And I guess the main point here is that if you're within this enterprise zone, and it might not just be Foxconn, it might be suppliers or other manufacturers within that area, the wetland process is accelerated. It's presumed that you have the right to fill isolated wetlands, and it's just a matter of working through the mitigation process.
Well, it is hard to take one message away from AB 770, given how much is done there. Just from my perspective as a lawyer who represents, I've worked for a lot of local government, but also represent a lot of private clients on land use issues. I really think that they're underlying this all is a lot of things that really maybe are in need of some taking a look at and getting addressed. And some good things in AB 770. I really only wish that it wasn't under the gun, so to speak, and such a rush to try to get it passed by the end of the session. And I think just the eminent domain section alone, I think there's a lot of things that really need to be looked at, and hooking up just compensation to relocation payments to ensure that, people are getting fairly treated when the power of eminent domain has to be exercised, but at the same time, not tie our hands in the use of that power, because, the bottom line is sometimes that is necessary, and if we are double paying or unreasonably increasing the costs of eminent domain, I think there's a lot of projects that just won't happen. So it can be a bad outcome for everybody. I just wish we had a little more time, and hope maybe that's the ultimate result, is the legislature decides to hold back a little bit on this and maybe put together a couple of study committees over the summer to look at some of these issues more in depth.
Yeah, and the remedies on public projects, I think the important thing is at the start of the job, find out who is who on the job. Who's the general contractor, who's the contracting public agency, who's the bond company, get a copy of the bond. Hello? And keep careful track of your notice and suit filing deadlines. Because I can't tell you how many times I get a request from a client saying, pursue a bond claim, and it's already way too late. And unfortunately, if you're too late, you lose it. So that's very important.
Thank you.
All right, well, thank you all again. I certainly learned a lot. Hope everyone here listened in feels the same way. And most importantly, I think it's time for lunch. I see the sandwiches back there. So, all right, well, let's wrap it up. Yeah, thank you again.
Thank you.
Yeah, lunch is back there, right back there. Thank you. We'll circle back with a